Members, this is the appointed time and we have a quorum. So I call this meeting to order. Item 1, meeting with the administration. Would staff please invite the administration to come in? We have the same team from the administration joining our meeting, including Ms. Ivy Law, Deputy Secretary for Environment and Ecology, Ms. Wendy Au, Principal Assistant Secretary for Environment and Ecology, and Mr. Arsin Yu, Deputy Director from the FGHT, as well as Ms. Vonda Lam, Government Counsel from the Department of Justice. Right. In relation to the list of follow-up actions arising from the discussion at the last meeting, would members please refer to CB bracket 2436/2025 bracket 01. We also have a response from the administration to these issues. That's bracket 02, paper number bracket 02. Members should have received a copy. And in relation to a letter from Ms. Doreen Kong to me, that's CB bracket 2343/2025 bracket 01. The administration likewise has given a response, and that's CB bracket 2442/2025 bracket 01. So would the Deputy Secretary please walk us through these responses, and then the floor will be open for questions. Yes. Thank you, Chair. Good afternoon. First of all, I thank members for their invaluable input in the past 3 meetings to help us improve the bill. Let me now turn to the list of follow-up actions required of the administration and our response. That will be our first task. We also have prepared some committee stage amendments, and I will go through them with members as we go on with the clause-by-clause scrutiny. The first point in the list is about the definition of litter. Members have asked the definition and specifically the difference between the word substance and the word article. Now, substance normally gives an impression that it is something intangible, and article instead would refer to something physical and tangible. We believe that by adding substance or article in the definition of litter, we will be able to better express the definition of litter, and that can also help avoid unnecessary disputes during FEHD's enforcement, as physical items may include smelly clothing and other unhygienic items. The second point refers to Section 86E2. Article refers to any stock in trade, whether living or non-living, and any other substance. Now, there are 2 limbs to this definition. One refers to anything that can be placed in a public place that can cause obstruction. The other is that we can save a repetition of this long definition in other provisions in Part 6A. This can help make the law more accessible. As for the definition of article in Section 86E2, it applies only to Part 6A and not other provisions in Cap 132. We don't think there will be any misunderstanding. Now, let me now turn to the next point about nuisance committed in public places. There are other provisions, and whether it is necessary to ensure consistency with other provisions. Having consulted the Department of Justice, we understand that Cap 132 seeks to make provisions for public hygiene and municipal services. The authority could issue notices according to Section 20 and 22A2 to request the removal of litter or the canopies on which the litter is sit, and to take action in the event of non-compliance. Cap 228 seeks to give a consolidate the offences relating to the Summary Offences Ordinance. and that there is no direct correlation between Section 2.1 of Cap 132 and Section 4.1 of Cap 228. The next point is about serving the notice of elimination of vermin and to whom should the notice be served, specifically which manager should be receiving this notice. Now, we will make use of the DMCs of the buildings and also information in the land registry, as well as consulting the owners and property management companies before ascertaining the manager of the premises. And we can also serve notices to more than one manager should there be more than one for the building. Now, about the definition of manager in Cap 344, having consulted the Department of Justice, we are of the view that manager under Cap 344 does not include owners' corporation. So this is in line with our policy intent. However, we do believe that there is more to be decided, and we are therefore prepared to amend the provision. And we will come to that in a moment as we reach the clause-by-clause scrutiny. Next point, in relation to Section 47(6), is the authority entitled to recover costs in relation to cleansing the relevant premises. Now, the provision refers to taking reasonable steps or take such other steps for the purpose of destroying and removing any vermin. We believe that the reasonable steps as referred to in subsection 4 cover the necessary reasonable cleansing work, such as collecting the carcasses of vermin, removing the unhygienic substances and the nests of the pests. And we believe that the new Section 47(6) should cover such scenarios in recovery of expenses. Members also ask in relation to Section 5(8) of Cap 132 to add Section 47(4)(b) in relation to examples of fittings, furniture, or equipment of a substantial nature. We've provided some examples in our response, including the central air conditioning system, stoves, and other large equipment. Next, in relation to 47(6), members have asked for the drafting to be improved so that costs can be recovered when placing equipment for the purpose of conducting tests or assessing rodent infestation. Now, according to legal advice, this is for the purpose of conducting tests or assessments as to the seriousness of the nuisance. We have no intention of recovering the costs in this regard. Now, in relation to Part 6A, members have asked the administration to consider adding a word space in between Roman numeral 6 and English letter A. According to the usual drafting practice, there is no need to add this word space. So, heeding to this advice, we believe that there is no need to add the word space in between. Lastly, in relation to Ms. Doreen Kong's letter, which refers to the offense of obstruction of public places and whether this is a strict liability offense. First of all, I thank Ms. Doreen Kong for raising this issue for us to be able to elucidate this point. Having consulted the Department of Justice, we are of the view that there are two elements to this offense. One is the placing of such articles without lawful authority or reasonable excuse. The other is that the article or substance causes danger or inconvenience. In relation to the first element, must act in a way as to place, suffer, or permit such articles to be placed, and it is for the prosecution to prove that the article has been placed by the defendant in such a manner. As for the obstruction part, it is an objective factual test, and the defendant's knowledge is irrelevant. The defense is available to the defendant, and that is lawful authority or reasonable excuse. The defendant needs to raise an evidential burden, and that the prosecution will need to prove the offense beyond reasonable doubt. So I hope I've answered all the questions raised by members at the last meeting. Thank you. Thank you, DS. Any further questions pursuant to the DS's response? Mr. Tony J. It's your turn. Each member will have 4 minutes. Thank you, Chair. Now, first of all, I thank the administration for responding to the various issues raised at the last meeting. The administration will be proposing amendments. I thank them for heeding our suggestions. Now, I'd like to comment on some drafting issues. You just referred to Part 6A, that's VIA. You mentioned that is the usual drafting practice, but it is problematic. It should be changed. If you insist on maintaining consistency, albeit wrong, then it is not reasonable. I'm perplexed. I don't understand why there shouldn't be a word space between the Roman numeral and the English letter. I really don't find any good reason not to make this amendment except to maintain consistency. Now, I'd like to comment on 126 and 126A. That's about additional 14 days. My question is whether this is a lax approach. That is a time limit of 14 days. I'd like the administration to elaborate this point, please. Yes. Thank you, Chair. Thank you, Mr. Tony Chair, for the question. Now, about the drafting practice, let me supplement. Of course, this is the usual practice, and this is, in fact, the established current practice. According to the Department of Justice's guidelines on law drafting, this is the drafting style currently adopted. So that's a point of information about 126A and the 14-day extension. When we first tabled the bill or floated the bill, we did not include a 14-day extension. In fact, we would mete out penalty when there is no reasonable excuse to refuse entry. However, heeding members' views, we believe that there should be a clear time frame for the benefit of the public, and after deliberations, we agree to adopt a 14-day time limit. Well, usually it won't take as long as 14 days. We will try to gain entry as quickly as possible. Only that if we have a time frame of 14 days, we can allow for a reasonable excuse. So that's basically the our consideration. Right, no follow-up, Chairman. Any other follow-up questions? Mr. Stephen Ho. About paragraphs 3 and 9, take such reasonable steps as so-and-so. If you talk to the vermin extermination companies, they would come up with some answers. But we once argued, for example, on a vessel where there are consignments, they may be valuable items. For even for waste paper, waste plastic, they carry a value as well. Well, maybe from the vessel owner's point of view, after cleansing, these items can be used or reused. So, should the matter be taken to court in order to resolve this dispute? We can have different scenarios, but I'm talking about a vessel on board of which there are consignments. Now, I want to know how this is addressed. We don't often go on board vessels, but I just want to make sure that this issue is addressed. Paragraph 10, you set out a list of examples. You try to be as exhaustive as you can. But what about major communication devices such as the GPS? At the end of the day, who is to decide whether it's a large scale or major device or not? How big is a big stove, for example? Because a decade down the road, the devices we use may not be the same. I'm thinking that perhaps 2 or 3 years later, you may need to come back and amend the provision.
Thank you, Chairman. Thank you, Mr. Stephen Ho. I'll take the question about large installations first. Regarding large installations, Mr. Stephen Ho is correct. In existing provisions, we don't have any examples. Instead, we generalize what is meant by large installations. This allows us to be flexible to include more larger-scale installations as time goes on. Regarding what makes a large installation, we'll have to have regard to the actual circumstances. When in doubt, frontline officers will make inquiries, and we may seek legal advice from the DOJ. May I suggest? Well, when you are not sure whether something makes a large installation, please keep it first. Regarding the question on vessels, we may not be able to provide any past experience, but the general principle is that frontline officers will use common sense to make a judgment. When the object owner is at the spot and when it is claimed that it is a personal property of that person, we don't incline to remove that object without the consent of the owner. If there is any dispute from the object owner that that object is the personal property of the owner, then one will have to provide proof. If one isn't willing to clear the object, we may prosecute that person, as that person doesn't comply with our directions. We want to try cautiously as we don't want to give rise to any further legal disputes. Frontline officers can contact the headquarters to make inquiries. We will seek legal advice from the DOJ. Well, I believe recyclables may be the most valuable. Say when cardboard boxes are folded into like dices, then there may be disputes. And we may have to take it to court even if we have set out everything clearly, and that is exactly what I don't want to see. Regarding 86H, that is how to dispose of articles removed or seized. Will it be more proper for us to ask questions when the administration is going to move any amendments? Yes, thank you. Any more questions from members? No? All right, let's get back to clause-by-clause scrutiny of the bill. Last time, 86G, that is C2319 of the English version. If members refer to the marked up copy, that is CB brackets 21719/2024 01. We'll carry on with the scrutiny of the bill. DS will take us through the provisions one by one. If members have questions, please press the button to request to speak. DS, please. 86G, removal of articles constituting unlawful shopfront extensions. Subsection 1. If a public officer authorized under subsection bracket 6 has reason to believe that an offense is being committed or has been committed under section 86F in respect of a business carried on in a shop, the officer may require the removal of such, and that provides a time restraint. Mr. Doreen Kong, while I have two quite material questions on section 86F, section 86F and G are interrelated. If your question is related to section 86F, I will allow your question. Thank you. In sections 86F and G, we see the phrase public place. Where can I find the definition for the term public place? Yes, indeed, there is a definition. In Cap 60, section 86E, public place has a definition. That is, it has the meaning given by section 2 brackets 1 of the Summary Offences Ordinance Cap 228. Under the Summary Offences Ordinance, is the definition the same as that in the Public Order Ordinance? Well, in accordance with the Summary Offences Ordinance, public place means a place that can be accessed by the public. Examples include piers, thoroughfares, streets, alleys, waterways, paths, and so on. Whether they are government properties or private properties. Thank you. Well, I'd like to make the point. Sections 86F and G will only be applicable when a place is accessible by the public. In theory, I'd like to point out for sections 86F and G will not be applicable. That is because the term public place has a definition. If one is smart as to put the article in a non-public place, then it won't be applicable. I'd like to point out the word access is material. Any response? No response? We've heard Ms. Doreen Kong's view. All right, let's carry on. The authority may remove, seize, or detain the article concerned in subsection 2. Please carry on. Subsection 3. If the authority acts for or on behalf of acts in good faith in respect of any loss or damage arising out of the removal or seizure, no one shall make a claim. Subsection 5. If the person from whom the cost may be recovered under that subsection consists of 2 or more persons, all of them are jointly or severally liable for the cost. And 6. The authority may in writing authorize a public officer for the purposes of subsection 1. Ms. Doreen Kong, I'd like to ask about subsection 3. No claim may be made against the authority if the authority acts in good faith. So when an article is being removed, how can I tell whether the authority is doing so in good faith or not? You need to let the public know how to judge whether the authority is acting in good faith or not. Thank you, Chairman. Thank you, Ms. Doreen Kong. We have drawn reference from section 23, section 22, brackets 5, rather. If frontline officers in good faith believe that something constitutes obstruction in public places, then it should be considered in good faith. However, in the event of personal grudges, then it will not be considered to be done in good faith. Mr. N. Kong, I have another question about Section 86G. Well, Sections 86F and G are drafted in a way different from that in the Summary Offences Ordinance. Well, I'd like to ask about Section 86G, brackets 1. In Sections 86F and G, if we read them in a minute manner, one will have to pass many thresholds in order to invoke Section 86F and Section 86G. One has to judge whether something is placed for the purpose of or in the course of carrying on of a business in a shop. Only in this case will Sections 86F and G be applicable. Therefore, I'd like to have clear guidelines and criteria to be given by the administration. In 86G, one needs to have reason to believe that someone commits an offense in relation to Section 86F. You need to be sure someone is doing so in the course of carrying on a business in a shop. So what if when a shop is closed, what if the object is not placed by the owner of the shop? Before restaurants open for business, someone may place food or vegetables outside a shop. So in this case, will you invoke Section 86G to remove such stuff? DS, thank you. Regarding Section 86F, we made it clear that it needs to be related to the carrying on of a business in a shop. That is why it targets shopfront extension. In some cases, shopfront extension may not be related to the carrying on of a business of a shop, so we won't invoke Section 86, Cap 2 to 8 rather. There are two parts of shopfront extension. One, someone permits an article to be placed in that in a public place. Someone needs to know that this is happening. However, if someone can provide proof that that article is actually not put by that person in question, then we may handle it in a different manner. If articles are put outside a shop for the carrying on of a business of the shop, that may constitute shopfront extension. If one fails to provide any reasonable excuse, then that person may be in contravention of shopfront extension. Under Section 86G1B, when someone puts the article outside the shop, what about delivery companies? Say when the companies deliver articles to the outside of a shop, then is someone still considered an employee or agent of the person?
86G refers to removal of articles. For For example, 86G1 provides that the authorized public officer has reason to believe that an offense is being committed under Section 86F, and that if there is reason to believe so, then the person should remove the articles. So the purpose is to remove articles as quickly as possible to address public nuisance. As explained before, we don't want the FHT to forfeit the commodities altogether. We'd like the owner of the commodities to remove them on their own, but of course there would be a law enforcement action that follows. Mr. Dennis Leung, I have one question on 86G1, definition of public officer. And that you'll find the definition in subsection 6. Now, if we go to Cap 132, to check the definition of the authority, according to the definition, it means the public officer designated to be the authority by the provisions of Section 3. And then reading these two together, it seems to be the public officer authorizing a public officer in writing. This is a loop. How should we interpret the relationship between the authority and the public officer authorized? Right. Yes. Thank you, Chairman. Thank you, member, for the question. Now, if we turn to Schedule 3, you will find the designated authorities, and that these authorities can authorize frontline officers as public officers, and then they are termed public officers so authorized. Please continue, Ms. Doreen Kong. 86G3. No claim may be made against the authority of the government, against any person, for on behalf of the authority of the government in respect of loss or damage arising from the removal of articles in good faith. Now, I must say that in Hong Kong we do not have a lot of loading and unloading areas. So let's say the loading or unloading of cargo is swiftly done, and yet the cargo is being removed in good faith, and because of subsection 3, no claim may be made. Is it fair, Chairman? In the Singaporean Act, it provides that loading and unloading activities are allowed within a reasonable time frame, and it's expressly provided in the Act in Singapore. In Hong Kong, however, we do not have the express provision. We want to encourage businesses, but these are not clearly provided here. Only when the matter is taken to court will you be able to put up a defense of a reasonable excuse. And subsection 3 spells out expressly that no claim may be made if the removal is done in good faith. I want to make sure that this is spelled out categorically to create a favorable business environment, because if you go to Kwun Tong, you will find a lot of unloading of cargoes not happening in the official unloading areas. So, Chairman, my suggestion is to make an express provision to give an exception for unloading and loading activities that happen within the reasonable time frame. FHT. What we heard members' question at previous meetings as well. Usually, our enforcement action does not include normal loading and unloading activities. Usually, when such activities are spotted, our officers will first advise or warn the persons involved to complete the activities as quickly as possible. However, if in our view these articles are put there for display, for sale, and not for loading or unloading, then we have a reasonable suspicion that an offense under 86F has been committed, and we can invoke this provision to remove the articles. So if our frontline officers are of the view after observing and obtaining evidence that this is not loading and unloading of cargo, but rather obstruction, then the article may be removed in good faith. And this subsection provides that no claim can be made against the department for acts done in good faith. Right, PAS, please continue. 86H. We are going to propose a committee stage amendment. Let me invite members now turn to CB bracket 2436/2025 bracket 03. This is in relation to 86H. We're going to delete the proposed section 86H. And will provide as follows. If the article is not of a perishable nature within 7 days after so-and-so, or if the article is of a perishable nature within 48 hours after the exercise of the power, then if the article is not claimed by anyone, then the authority may forfeit the article to the government. And then subsection 2, if the authority is satisfied that the claimant was entitled to the possession of the article, then the article may be returned to the claimant. Mr. Lam Chun Sing. My question is on bracket B. If the article is of a perishable nature, dispose of it immediately. That's what it originally reads. Now you have made an amendment and you provide a 48-hour deadline. So that's my question. Originally, the bill provides that the perishable article can be disposed of immediately. Now, you wait for 48 hours. Is it necessary for it to be removed? Is there any discretion in the process? Say if the perishable item is so rotten that it affects public hygiene, and that even the frontline FEHD officers find it difficult to dispose of the articles. I want to know whether there is any alternative. Is it possible to have an alternative other than to seize the article and keep it in, say, a freezer? I don't know whether you have storage facilities like those. Because if you can't allow for discretion to be exercised, then I just want to make sure you have the proper storage facilities. Well, I think this is the consensus forged after a lot of deliberations. I will ask the DS to elaborate on this. Thank you, Chairman. Thank you, Mr. Lam, for your questions. About the proposal to extend the time limit by 48 hours, having listened to members' views, it is agreed that a time frame should be set for the claimant to make a claim for the article seized instead of destroying or removing the article immediately. We find the 48-hour time frame reasonable. Next, Mr. Tony J. I don't know whether the issue should be raised now or later. About disposal of the article, in fact, bracket B, and I'm referring to bracket 1B, it is said that the value of the article should be assessed. That's in fact in 2B. I don't know whether I should hold this point until we reach bracket 2. I just want to know whether there is any time frame in assessing the value of the article. Say, if you seize this article and if the article is of a perishable nature, then at the time of seizure, the article may be all right. But after 48 hours, this article of a perishable nature may now carry a different value. Well, take seafood as an example. Fresh seafood may carry a value that is totally different from a seafood kept 48 hours later when it's no longer alive. So how should the assessment be made? Is there a time frame in relation to disposal of perishable articles? I'll ask the PAS to elucidate this point. Please go through the whole section with us again. At the last meeting, we reached a consensus with members. For the sake of administrative convenience and efficiency, we propose to include a time frame of 48 hours for claimant of perishable articles to make a claim. If they fail to show up and make the claim within 48 hours, then the article can be disposed of, and as such, there is no need to assess the value. We have deleted this provision, in fact. Is it clear, Mr. Chair? So B has been deleted. Right. So if nobody comes forward to claim the article within 48 hours, there is no need to further assess the value. Right. I think the question's been answered. Ms. Doreen Kong. Chairman, I'm referring to the latest version, not the old version. And I'm looking at 86H. It says that the power under section 86G2 has been exercised, but in 86G2, the powers include the power to remove, seize, or detain the article. So let's say I remove the article to somewhere and then I seize it and detain it. As long as I exercise one of these powers under section 86G2, then the authority may forfeit the article to the government. Now, I think you should think twice. Now, imagine this scenario. Let's say if the article is put aside and then no obstruction will be made out, because 86H refers to articles being removed, seized, or detained, or articles to be removed. Now, according to 86H, if the power is exercised under 86G in respect of an article, the authority can then forfeit the article, and that's a big deal. The other point is this. You need to explain the power to be exercised under section 86G2. Exactly what power is it? If all articles can be forfeited to the government, then shouldn't you at least inform the owner of the article, or shouldn't you at least publish a notice at the place of seizure? My third question is article of a perishable nature. I want to know what it means. In Chinese, it's 以为烧, that means perishable. Well, abalone, in my view, is perishable. So you need to explain very clearly what it means. Does it mean that it rots easily, or it can be digested easily upon ingestion? The fourth question is this, about 7 days and 48 hours time frame. What if public holidays are involved? Say during Chinese New Year, after 48 hours, it will still be a public holiday. Is it too harsh on members of the public? I'd like the administration to respond to that, please. Yes. Thank you, Chair. Thank you, Ms. Kong, for your questions. Let me take them one by one. About articles to be seized or removed, it refers to the Frontline Officers Act. Second, whether a notice will be published. Yes, we will post a notice at that place, and we will warn the owner of the possible construction offense, and only when no action is taken will we remove the article. About perishable article of a perishable nature. Now, I agree with Ms. Doreen Kong that we need to consider the nature of the article. Say for dried abalone, it can be stored for a long time. It is not regarded as a perishable good. But if it's something sliced, then it can rot easily. It may be regarded as a perishable article. We do have guidelines for our FEHD officers. Now the last question is about the time frame and public holidays involved, whether 48 hours would be too short a time frame. First of all, we allow the owner of the article to make a claim to take back the article. I mean, at the time of warning the owner, we give the owner the chance to remove the article themselves. And only when no action is taken will the FEHD seize the article. Now, if the article is of a perishable nature, even during Chinese New Year, this item will eventually rot. So the claimant, if he so wishes, should claim for the article to be recovered within 48 hours. And once this claim is made, our officers will make arrangements.
All right, clear? Yes, thank you. Next member, Mr. Lam Chen-seng. Thank you, Chairman. When some articles are taken according to 86H brackets 2, when someone claims that the article belongs to him or her, and when you are satisfied that the article belongs to that person, then you will return the article to that person in question. But what if you are not satisfied about this? How will you deal with it? In the old version, a large chunk of the text is deleted, say in relation to the assessment of the value. In the old version, does the claimant have the right of possession of the article? You include relevant provisions, such as how the court will handle these cases. However, in the new version, you deleted all these texts. If the administration is not satisfied according to the new according to the amendment, how will you deal with it when the old version is deleted? Well, under the new arrangements, one can go through the small claims tribunal when the value is below $75,000, or to the district court when the value is below $3 million. And then someone may lodge a claim in these courts of law. So you think you do not need such detailed provisions, hence they can be deleted, as that won't have to be handled by the court. Is that correct? Yes, we can handle it according to the current mechanism. Mr. Doreen Kong. Well, excuse me, according to the current mechanism, someone may lodge a claim. Is that correct? Just now you mentioned an ordinance that one may invoke. Which ordinance is that? Chairman, let me supplement. Thank you, Mr. Doreen Kong. For articles in relation to shopfront extension, the FEHD in general return the article to the owner. That is because when someone comes to claim the articles, then it means someone admits the liability. And I don't believe there will be a lot of people who come to claim the return on the articles if they aren't in their possession. In some cases, when we doubt the person is the owner of the article, then that person can make a claim to the administration. Say one can go to the small claims tribunal or the district court for claims. We estimate that there won't be a lot of these cases. So in drafting these provisions, we have taken on board members' views. We want to keep it simple. That's why we didn't add such details to the provisions. Well, Chairman, I asked this question because I thought I had misunderstood it. Well, the current provision is that no one can make a claim. That is, no claim may be made against the authority or the government in relation to any loss or damage. 86G(3), you said that no one may make any claim if the authority is acting in good faith. So can you tell me in simple terms whether one can do so or one cannot do so? Thank you. 86G(3). Well, let's take a look at 86G(3) together. No claim may be made against the authority or the government, or against any person acting for on behalf of the authority or the government in respect of any loss or damage arising out of the removal, seizure, or detention of an article in good faith. In this case, no one shall make a claim against the authority or the government. Say, when something is chipped, one cannot make a claim for such damage to the article when the authority is acting in good faith. In this case, no one may make a claim. In general, when one makes a claim, we will return the article to the person in question. However, in some cases when we doubt that person is the owner of the article, then that person can make a claim with existing channels. Is your question answered? Yes, let me get to section 86H. When you seize an article, is there any list? I mean, a list of the articles seized. Will members of the public be able to access a list of the items seized by the administration? Well, at present, no. Well, let's suggest you need to have such a list. Members of the public want to know whether some articles have been seized by the administration. They want to know the whereabouts of the articles. You may consider it. Well, when we need to remove articles in relation to shopfront extension, the owner of the article is the one who has stake. So we inform that person. We also post a notice in the area where the article is removed. So we believe the owner of the articles have been informed of the fact that some articles belonging to that person have been removed. Well, I have to say I beg to differ, Chairman. If someone is seized by the government, then it belongs to the government. Why isn't there a list? When you put the articles to auctions, for example, we need to make it clear. We need to show a list. Say if you seize 100 cans or 10,000 cans of abalone, we need to keep an inventory to prove what exactly the administration has seized. Members of the public have the right to know. Thank you, Chairman. Thank you, Ms. Doreen Kong, for her view. We'll consider it. Thank you. Mr. Stephen Ho. I understand Ms. Doreen Kong's concerns. We have been working in the community for a long time. It is not a good idea for the administration to break open the cans of abalone. The administration should keep these articles for a short period of time. It is not the case that these articles would immediately become property of the administration. They will only become properties of the administration after 48 hours. In that case, they will go to the inventory of the administration after 48 hours. It is important whether members of the public know certain articles have been seized by the administration. So at this stage, I don't agree that we need a list. Ms. Doreen Kong's concerns are legitimate. I understand that. Well, the provisions are clear, and the DS said that they would look into it. Yes, indeed, we will look into the views of members and consider them all together. Thank you. Regarding Section 86H, any more views? Legal advisor. Thank you, Chairman. I have 2 points to raise. 1. 86H brackets 2 amendment to be proposed by the administration a person doesn't have to pay before an article is returned, and that is different from the current provision of Section 86H brackets 2. The administration mentioned only for persons who have not been convicted will be able to get back the article in question. In the amendment proposed by the administration, there is no such mention. Can you tell us more about this? DS. Thank you. Regarding the first part of the question in relation to fees, that is, one will have to pay before one can claim the article or claim for the return of the article. We have added the 48-hour window. Well, in the calculation of the value of the article by the FHD, it will take some time. And we don't want to cause any delay to the return of the perishable item to the owner. Otherwise, it's meaningless. We want to provide for a mechanism by which we can recover these fees. For those who have not been convicted, we will return the articles to these people. Members had a consensus that is within 7 days. Well, an article will come to the possession of the administration, so there is no question of whether a person is convicted or not. Any more question? No. That is Clause 7, Section 104C amended power to remove bills and posters. That provides for power to remove bills and posters or display equipment. If no claim is made within 7 days after the date of the removal for its return, the authority may forfeit it to the government and may dispose of it. And no claim may be made against the authority or the government in respect of any loss or damage arising out of the removal of a bill, poster, or display equipment. Mr. Tony Te, I'd like to ask about display equipment. There's a definition under Clause 8. Display equipment in relation to a bill or poster that is displayed means any structure, apparatus, or hoarding used for the display. Does the word apparatus cover a wide range of objects, say, are vehicles included? After all, within 7 days, if no claim is made, the authority may forfeit it to the government. And I'd like to ask about the disposal or the dealing of the article as well. For tablets, LED TVs, for instance, someone simply carries that objects on their back and walks in the streets. is very popular in Japan.
Right. Let me first take the latter question, whether somebody carrying a display board on his back is regarded as a display equipment, and then I'll take the question on gadgets. Now, if somebody carries a display board on his back, then he is not caught by this section. Well, I know that this is covered by another provision. I mean that this person may still be breaching other provisions. Maybe this is another obstruction offense. Thank you, Mr. Chair, for the comments. That depends on the circumstances of the case. For example, somebody may be wearing a T-shirt or may be putting up a board on his chest and he's walking around in the street. It's really difficult to prosecute this person for causing obstruction in a public place. But if the equipment is of a substantial nature, then he may be caught by another provision. So that really depends on the facts of the case. Only that this may not relate to the bill or poster offense as set out here. Members ask in relation to display equipment whether this is an exhaustive list provided, meaning structure, apparatus, or holding used for the display. I'd say yes, this is an exhaustive list in relation to a bill or poster that is displayed. In Cap 132, there is no clear definition provided, so we rely on the general interpretation of the wording. Right, for example, if you use a vehicle for the same purpose, then the vehicle can be removed. And if the vehicle is not claimed within 7 days, it can be forfeited. Can I take it that way? Who will take this question, please? DS or DOJ? Because this is an exhaustive list. Is that right? Because according to what the DOJ representative said, it is an exhaustive list. So is my understanding correct? Now we can go to 104 subsection 4. That is in relation to bill or poster. That means anything that is painted or displayed, or that some words are displayed on a rock on a wall. It doesn't exactly provide the way of display here. So our understanding is that as long as the court finds this to be a display equipment, then an offense is made out. Right, understood. Next, Ms. Kong. Well, we have elections coming up, Chairman. Electioneering posters, it's easy to understand. What about collapsible or easy mount frames? We often see easy mount frames placed in the street unattended. According to 104C, they can be forfeited. Is that right? The premise under 104C is that the easy mount frame is placed there without permission, then it can be removed. Now, if the easy mount frame relates to electioneering, then and if it has the permission of the authority to be placed there, then it can be placed here. Right, but usually easy mount frames or electioneering materials cannot be placed in the public place. Then according to 104C, these can be forfeited. Now, in fact, you should first apply with the Lands Department for placing the articles there, and there are also guidelines during elections for candidates to put up posters or bills or easy mount frames in a legal manner. Chairman, I'd like to go back to the term display equipment. Mr. Tony Chair asked a very good question. So display equipment, in theory, must be something on display somewhere. Say if we have somebody holding a placard in the streets of Hong Kong or Macau, asking people to go to a side street for fish balls, then in theory, the placard cannot be forfeited. Is that right? As long as I'm walking all the way and I'm wearing a T-shirt under Section 104C, these things are not regarded as display equipment. Is that right? I think the point was covered already. Indeed. Say if somebody wears a T-shirt and on the T-shirt it writes, please go and buy this and that, then it's not regarded as a bill or a poster that is displayed. So 104C does not apply. Mr. Benson, look. Chairman, I have a question about this part. Can you tell us some common examples in order to illustrate what exactly you're going after? For example, in Mongkok, we often see two types of business activities. One involves people holding up boards, display boards, inviting patrons to go to restaurants, and they will not be prosecuted, right? And for the second type, there are salesmen putting up display boards, easy mount frames in the street for the purpose of sale. Then it could be caught by the law this way. Is it what you're going after? Sometimes we see posters or easy mount frames tied to railings. Deputy Director, yes, the member has made a very good point. For example, you may have staff members holding up display boards, wearing advertising T-shirts to advertise a business, then this is not caught by 104C. Now, for the other kind of activities, we used to see bills and posters stuck on the walls of buildings, etc. And on top of that, we are now seeing more and more easy mount frames placed on the street, unattended. We want to make this provision to be able to remove these easy mount frames. Next, Mr. Stephen Ho. Well, I wanted to ask what Mr. Benson Look had already asked. But anyway, I'd like the administration to elucidate the point. You need to explain the legislative intent very clearly. Usually, we see bills and posters providing plumbing services posted on the walls. But there are also other people that may hold up boards advertising fish balls or giving out brochures for new developments, and also people having easy mount frames inviting people in the street to switch to another telecom service, for example. Now, of course, the government goes after bills and posters posted in the public place. But for the other kind of activities, I think you need to make it clear how you can exclude the latter example that we just went through. Now, it's hard to get this just by reading the provision. It's for the government to do the explanation. Thank you, Mr. Stephen Ho, for his comment. This is in fact stemming from a current provision. It's in existence and enforced for quite some time. And on this occasion, we strive to include easy mount frames as a display equipment so that we don't need to take a separate approach when dealing with easy mount frames. So that's the purpose of this amendment bill. Now, of course, there are different scenarios. You mentioned telecom companies making use of easy mount frames to advertise a business in the street. We do take enforcement action against those frames. After all, this ordinance has been in place for some time and is familiar to members of the public. So that means if it's an easy mount frame attended by somebody, then it's not against the law and no enforcement action will be taken. Now the explanation is clear. Originally, we had bills and posters. Now you're adding easy mount frames. That's it. And other kinds of economic activities will not be touched upon. And I think this is a message you need to hammer home to the public. It is not the case that after passage of the bill, one cannot hold up any display board to advertise their business, one cannot distribute leaflets, etc. You need to make it clear that this amendment bill does not touch on these activities. Ms. Doreen Kong. I often visit old districts and I do come across some light boxes advertising foot massage. And I've been reading the whole section. Now that you propose to add display equipment in 104C or 104C, now say it's all right to place this advertising light box in private premises, but if this light box is placed in a public place advertising Thai massage or foot massage, then under 104C the box can be removed. Right. Please continue. Clause 8 amends 104E, providing a definition for display equipment. And that is, we are moving the provision in 104C to 104E. That is from subsection 4 to subsection 3. Next, clause 9. Section 126 amended about general powers of entry. We are going to add subsection 5. In 5A, the FEHD staff can enter any premises for investigation until 10 p.m. So that's an extension from 7 to 10. And then B, about the occupier of premises being owner or occupier. And then C, a corresponding amendment to subsection 5A. And that is the time frame will start not from 7 p.m. but from 10 p.m. Ms. Doreen Kong. 5B. Right, I need to read the text on the left-hand side as well. But anyway, if it's a public place, then to whom should it be given? Is it the owner, occupier, or the manager? I'm sorry. I want to make sure that it is provided on the left-hand side as well. Well, it's about gaining entry, is that right? Let's go to 5B. A reference to the occupier of any premises in subsections 1 and 2 is to be construed as a reference to the owner or occupier of the premises. I'm trying to give some help here. Now, when we ask about cleansing operations, the notice will be issued against the property management company or the manager. Now, let's say if you want to gain entry to a common area, then in the same token, the notice should be served to the owner's corporation or manager of the property management company instead of just the owner or the occupier.
DS. Thank you, Chairman. Thank you, Mr. Doreen Kong. Just now, Ms. Doreen Kong mentioned 47. We will provide a clear explanation later on. In relation to causing obstruction, we have the power to gain entry to the place. In that case, in a public place, it has an owner or an occupier as well. So this provision covers that as well. Well, basically, the owner or occupier of a public place basically means all the owners. So I want to make it easier for you. Will you go back and take a look at it? In the case of public places, if you refer to all owners, then it will be difficult for you. Thank you, Mr. Kong. Thank you for helping us to improve the drafting of this provision. In general, public places are places that can be accessed by the public. Even if this is not possible, the public can access a public place after talking to the manager of the place. We already have a provision whereby the owner or occupier can be got a hold of in order to allow the public to access that place. Clear? Yes, thank you, Assistant Secretary. Clause 10, Section 126A added offense of failing to allow certain entry. First of all, our new amendment is that a person commits an offense if someone doesn't comply with the direction. Well, our current drafting is that we divided A and B. The owner or occupier needs to allow the public officer to enter the premises. And in order to allow the FEHD to approve applications submitted out of time, the owner or occupier of the premises, the administration will, or the authority will make an assessment in order to decide whether approval will be granted. Thank you, Chairman. In Section 126A, Bracket 2, the Director of Food and Environmental Hygiene isn't set out. The provision doesn't specify the public officer of the authority, so will it be more appropriate to use the Director of Food and Environmental Hygiene instead of the authority? Will it be more appropriate? Thank you, Legal Advisor. Section 126A 1C, Section 126A brackets 2. That is, for the purposes of subsection brackets 1 brackets D brackets 2, the authority may, on application by the specified person, by written notice given on the specified person. Section 126A brackets 1 bracket C sets out clearly that the officer is the one authorized by the Director of Food and Environmental Hygiene. That's why it is clear that the power of the Director of Food and Environmental Hygiene is required or is needed. Well, when the authority is mentioned, it refers to the third schedule under the bill. So should 126A be amended to replace the authority with the Director of Food and Environmental Hygiene? This will be clearer. Should it be done this way? Thank you, legal advisor. We'll go back and study this point. This is a technical issue and we'll follow up on it actively. Thank you. Thank you. Please carry on. The following are technical amendments. Clause 11, first schedule amended. We add scheduled offenses so that authorized public officers can arrest persons who are believed to have committed an offense. Clause 12, third schedule amended. Designated authorities. We set out the authority as the Director of Food and Environmental Hygiene. We will amend Schedule 6, or the 6th schedule. We will add some offenses to 6th schedule in order to provide for a clearer background, and we'll move an amendment about this. Clause 13, 9th schedule amended. First of all, brackets 1, we repeal 22 brackets 1 brackets A from level 2, that is $50 fine per day, to level 3 and $300 of fine per day. Brackets 2, 9th schedule repeal 47 brackets 2 brackets A from level 2 to $100 of fine per day, to level 4 and $450 fine per day. And for the other offense, it will be raised from level 1 to level 2. And 9th schedule, after the entry relating to section 83B brackets 3 at 86F level 4 and 3 months of imprisonment. 9th schedule, repeal 104A brackets 2 level 3 to level 4, $300 of fine to $450 of fine. Please pause. Mr. Tony Tse. Regarding shopfront extension, there is an imprisonment term, whereas for the offenses mentioned just now, there are no imprisonment terms, only fines. Can you tell us why? For repeated offenders, why do some warrant imprisonment terms where some only warrant fines? Thank you, Mr. Tony Tse. Regarding offenses in relation to shopfront extension, in previous meetings, we already explained that we have no intention to amend the offenses under Cap 228. We only empowered the FEHD to remove articles in relation to shopfront extension on their own. So we are using the penalty under Cap 228. We use the proportionality under the law, and the fines haven't been adjusted for a long time, since 1996. We have the public support after the consultation period, so that's why we are going to introduce this amendment. Well, it's a big deal if someone may be thrown behind bars. The maximum term of imprisonment may be up to 3 months. You may need to explain more to the public. You need to explain why in some cases you are following the existing practice, whereas in some other cases you aren't. You may want to give it some thought. DS. Thank you. As I said, we are following the penalty under Cap 228. To me, shopfront extension may be more serious offenses. We don't have a lot of land in Hong Kong. If someone occupies a lot of public places, the potential interests or benefits may be substantial. That's exactly why it would attract a heavier penalty. Mr. Doreen Kong, I'd like to write on Mr. Tony T's question. It's indeed very good. I'm not going back to policy discussions, but in relation to shopfront extension under the existing bill, in accordance with Cap 570 fixed penalty ordinance, there is a fixed penalty, and in marked up copy, page 44, $6,000 for shopfront extension. In 86F, however, under what circumstances will you exercise the power under Cap 570 and mete out a fine of $6,000? Under what circumstances will you mete out penalty of level 4 fine? FEHD. Thank you. We give guidelines to frontline officers for simple and direct cases. Frontline officers should use fixed penalties to deal with these cases. Whenever there are doubts, disputes, or more complicated facts, frontline officers can note down the fact of the case and choose not to mete out fixed penalty. Instead, they may deal with the case by way of summons. When there is any dispute, in the end the case will go to the court, and the court will look at the current provisions. In the case of conviction, the existing level of penalty will be used. Ms. Doreen Kong, well, someone may be imprisoned in the case of contravention of this ordinance. In theory, you may give me a fixed penalty ticket. In the case of any dispute with the public officers, chances are you may not use fixed penalty in this case. Is that correct? Well, you may put it this way. The directions we give frontline officers is that fixed penalties apply to simple and direct cases, meaning the cases that don't have to go to court. Offenders may not have to be held criminally liable when they pay the relevant fine. For littering, for example, fixed penalty may be used. These are simple and direct cases. For cases with more complicated facts, frontline officers may choose to use summons to deal with these cases. The cases may then go to court. The court will make a ruling. Mr. Doreen Kong, well, what if I'm a barbaric member of the public? Definitely one will face a fine. What you mentioned just now is a simple and direct case, but it wasn't mentioned in the bill. If a member of the public only places few articles on the streets, then he or she may not be engaged in a dispute. That is if the court accepts the explanation given by the member of the public, then the fine will be less than $6,000. Then definitely members of the public will go to the court. Well, for any person receiving the fixed penalty ticket, of course, one can raise any challenge. If frontline officers think that the cases are simple and direct, then fixed penalty ticket may be issued to the offenders. If the offenders want to take the case to the court after the issuance of the fixed penalty ticket, then that person can still take the case to the court. There is such a mechanism in place. As to whether a case is simple and direct, the views of the offenders will be taken into account, but in the end, frontline officers make a judgment based on our directions as to whether a fixed penalty ticket will be issued. Thank you.
Subsection 5, another amendment to 9th schedule. In relation to 1268, refuse to obey order to allow entry, we are going to add a level 2 fine. And in relation to 1268's amendment, we are changing the reference here to 126A1, and this is a committee stage amendment. We will also amend 1273 from level 3, that's $200 fine, to level 4, $450 fine, and then 1273B, a level 4 fine, $450 it will be increased to level 5 fine, that is $600. Mr. Tony Chair. Thank you, Chairman. I'd like to seek an explanation on 126A about fixed penalty ticket and taking the matter to the court. Have you considered the fact that the fixed penalty ticket is more effective? Or is there a problem with the payment of fine? You haven't considered fixed penalty tickets. Now, the fixed penalty ticket mechanism can serve great deterrence. Who will take this question, please? Deputy Director. Thank you, Chair. Now, I think coming back to the principle of fixed penalty ticket offense, it should be a straightforward offense, and that no determination from the court is required. Here, for 126A, it involves non-compliance with a notice of proposed entry into a premises. So we allow a 14-day period for the defendant to raise the defense of a reasonable excuse. And we're referring to the non-straightforward cases. For example, the defendant is away on business, but did the defendant inform anyone? So in the course of collecting evidence, if we believe that the provision has been breached, we will provide evidence for the court to decide, and we believe that for such cases it's more appropriate for the court to make a ruling rather than issuing fixed penalty tickets. Now, we want to enhance the efficiency of or the effectiveness of law enforcement. Chairman, we need to have regard to the long waiting time for cases to be heard in courts and the resource implications. Have you considered these matters? Yes. Thank you, Chair. Thank you, Member, for the comment. Deputy Director already explained the mechanism. Usually, for fixed penalty tickets, this applies to straightforward cases, the handling of which is also straightforward. Otherwise, after receiving the notice according to Cap 570, this defendant can make an objection by making representation, and this can add to the burden of the courts. And that is why for 126A, if a person fails to allow entry of an officer, a public officer authorized without lawful authority or reasonable excuse, then for this offense, we believe that the fixed penalty ticket would be more appropriate, because if we impose a 14-day time frame in the majority of cases, our officers will be able to gain entry. Next, related amendments to fixed penalty public cleanliness and obstruction ordinance cap 570. In Schedule 1, we're going to include a shopfront extension offense so that the FEHD officers can issue fixed penalty tickets for these offenses, and that the fine of $6,000 can be meted out. Schedule 2 will also be amended, and that the Director of Food and Environmental Hygiene will be the authority. Chairman, I have completed scrutinizing going through the major provisions, and I will also go through the amendments about 47(2)(a). That's clause 5.5. Now, as background information, 47.1 enables the public officer to issue a notice of elimination of vermin to the owner or the owner's corporation or manager. Now, if the notice is not complied with, the government can proceed to destroying or removing the vermin and recover the costs afterwards. In light of members' suggestions, we are going to revise the drafting of 47(2)(a), such that it now reads: if the notice concerned is one that is served under subsection 1A, the authority may recover any expenses under subsection 2B only if the person on whom the notice is served is an owner's corporation. This will clarify the position of our public officers' recovery of costs from the owner's corporation. Now, if the notice is issued against the manager, and if the manager fails to comply with the notice, we can also invoke section 47(2)(a), which means a level 4 fine and $450 of daily fine. I already mentioned that in the proposed amendment to the 9th schedule. Any questions, Ms. Doreen Kong? I have no objection to the proposed amendment to section 47(2)(a). We need to spell things out clearly. If the management company or the manager fails to comply with the notice, then the authority may recover the expenses of cleansing from the management company. Now, I also understand that even if the cost cannot be recovered, it's still against the law, and I know that this is rather serious because it entails a level 4 fine and a daily fine of $450. Now, the property management company does the bidding of owners. So if the management company is in the wrong and then the company is fined, then will the penalty be transferred onto the shoulders of owners? Let's say for a fine of $30,000 for a building with her owner's corporation, then is it possible that a dispute may arise as a result of owners having to pay for the penalty imposed on the property management company? Now, if I understand Ms. Kong correctly, her question is whether the property management company is able to recover the penalty from the owners, and that's for both parties to decide. Now, for cleansing operations, we set out very clearly in the notice the parts in the common areas to be cleansed and the steps to be taken. So if it's a PMC of a housing estate and that is the manager, there should be resources for the company to comply with the notice, and we believe that there is no reason not to comply with it. My other question is this, Chair. My understanding is that in the event of not having an owner's corporation, the authority cannot recover any expenses from the property management company. Still, expenses are made out, the authority will need to recover costs in other ways. Does it mean that you will issue another notice under 47(1) requiring the owners of the property to repay the government? Thank you, Ms. Kong, for her comments. Her understanding is correct. PAS, all done? Yes. Members, we've basically gone through the scrutiny of the bill. I will first ask the legal advisor to confirm whether there is no problem with the English rendition of the bill. Apart from the issues raised previously in our letters, we have not identified any other drafting issue in the English version of the bill. Right, I believe some issues have been raised. Follow-up action is needed. I would ask the administration to give a response to the issues raised by members today. Please do that in writing. Coming back to the amendment, basically we also examined the proposed committee stage amendments. So let me confirm with the administration whether this is the case. Yes, apart from the technical amendments which will be added later. We received the proposed CSAs rather late. I think our legal advisor will need time to go through them again. So after she's done so, we will ask the legal advisor again, and that perhaps after we've received a response from the administration, we'll circulate both for members' reference and decide whether another meeting is needed. Just a reminder for members, if you want to move any amendment to the bill, please give notice as quickly as possible. And that means before the 18th of March. Please submit your proposed amendment to the Secretariat. So as I said, after receiving a response from the administration, we'll circulate it to members. And if need be, we can convene another meeting. Any views? Mr. Dennis Lau. Thank you, Chairman. The legal advisor referred to 86H. I understand that they've proposed an amendment, and DS also mentioned a separate mechanism for recovering costs. I want the administration to provide this response in writing so that there is clarity for our benefit. After seizure of the articles, how should they be handled? Or after the articles have been claimed, how will the government recover costs? Please provide a response in writing. Right, with the DS, please note the members' requests. Give us a written response. Apart from written response, we also need a set of CSAs proposed, and they will be circulated to members. Legislative timetable. Let me ask the administration to explain the timetable to us. Any special consideration? Thank you. We'd like to resume second reading as quickly as possible, barring CSAs and further communication with the legal advisor. We'd like to table the bill back into the Council as quickly as possible. Right, if you have a concrete timetable, do let us know as quickly as possible. Right, as I said, once we receive the papers, they'll be circulated. If there are no problem, there are no problems. There won't be another meeting, and if need be, we can call for another meeting. All right. Item 2, AOB. Nothing under AOB. Meetings adjourned. Thank you.